I suspect that Mr. O'Neill may be correct in saying this case is unique in having 3 members of the House of Lords addressing it.
Whether that's an advantage the court may not need to pronounce upon.
Or perhaps a precedent.
My ladies, my lords, I gratefully adopt the submissions that the court heard this morning from the Lord Advocate, from Mr. Fordham and from Lord Garnier. The court has received comprehensive oral and written submissions over the last 3 days. And I therefore wish in my reply just to emphasise what we say with respect are the central errors in the arguments advanced by my friends Lord Keane and Sir James. And may I say something about the facts and then the law, and then can I address the remedy, as my friend Lord Keane did. Now, on the facts, we say the central issue is why was it appropriate to prorogue for 5 weeks, longer, as the court knows, than on any occasion in the past 40 years. And Lord Keane's response when this question was put to him was that the prorogation was not in substance for 5 weeks, because 3 weeks of the period would have involved the recess of Parliament for the conference season. Therefore, in truth, the prorogation is for 7, I think he said, 7 working days of Parliament. Our response is we say that does not explain, far less justify, closing Parliament for 5 of the 7.5 weeks prior to the 31st of October, having regard, of course, to the adverse effect on the ability of Parliament to perform its scrutiny functions at this critical time. Why do I say that? Well, because first, as Sir James and Lord Keane both accepted, it is Parliament, not the executive, which decides whether to have a recess for the conference period. Parliament may or may not have decided to have a 3-week recess this year when the 31st of October is fast approaching. The Prime Minister's decision took that matter out of the hands of Parliament. Secondly, even if there was a conference recess this year decided upon by Parliament, Parliament would still, during those 3 weeks, have been in session. And therefore, written parliamentary questions could have been asked and would have needed to be answered. And parliamentary committees could report and would report. The court knows that it's been a regular feature of the past few months, at least the last few months, that parliamentary committees have been reporting and reporting urgently on all aspects of the Brexit process. So some degree, an important degree, of parliamentary scrutiny would still have been available. And this prorogation for 5 weeks at this time prevented any parliamentary scrutiny for that period. And the third answer to Lord Keane is the point put to him by my Lord Kerr and my Lady Black. And your Lordship and your Ladyship asked Lord Keane to explain why there was any need for a prorogation prior to the 7th of October or thereabouts. What was the reason? And there was, in my submission, no answer to that central question.
Prior to which date did you say?
The 7th of October, a week or so, not precisely, but around the 7th of October. What was the need for a prorogation prior to that date, was the question put, if I understood correctly, by my lord and by my lady. And I say, court heard the answers, I say there was no coherent answer to that question. The documents on which Lord Keane relies in relation to this whole matter include, let us not forget, the note dated the 16th of August in the Prime Minister's own handwriting. It was read out yesterday by my friend Mr. O'Neill, and I don't ask the court to go back to it, but it's in the Miller Trial Bundle, tab 39, page 316, electronic page 379. And it's the one where the Prime Minister says the whole September session, these are his words, is no more than a rigmarole to show the public MPs earned their crust. That's what it says, and that's his words. And I'm very happy for the court to follow Lord Keane's approach that he articulated a few moments ago. Read this document fairly and with an open mind. There's no need to adopt any incendiary language, Lord Keane's criticism of my friend Mr. O'Neill. The document speaks for itself. And what does it show? It shows the Prime Minister's failure to understand that Parliament, as the sovereign body, will wish to ask questions of the executive, to debate matters, to report through its committees, possibly enact more legislation. And it will wish to do so during these September weeks concerning the negotiations, if any, with our European partners and the planning for no deal. And I was asked on Tuesday by my lady, Lady Arden, about the bills that were lost because of the prorogation from the 9th of September. And the court now has the answer, detailed answer to that question. And there's no dispute. The government's note accepts that a number of important bills have been lost. They include, incidentally and sadly, the Courts and Tribunals Online Procedure Bill, on which, if I may say so, Lord Keane worked tirelessly and skillfully to pilot through the House of Lords. It's one of many bills that have been lost. Now, Sir James points out, and he's absolutely right, that it is inherent in prorogation that bills are lost. But my lady, Lady Arden's question is important because it provides a further answer to the Prime Minister's suggestion in his handwritten note that I mentioned a few moments ago, that Parliament has got no business to transact during this period. So what's all the fuss about? The bills, some of them very important bills, that were being debated, that were going through the stages of both the House of Lords and the House of Commons, demonstrate the error in the Prime Minister's analysis. And we therefore maintain our factual submission made in opening that this 5-week prorogation has prevented Parliament from carrying out its scrutiny functions over the executive for a period of exceptional length, longer than any prorogation in the past 40 years, for no rational reason, and at a time when the constitutional principle of the executive being answerable to Parliament is of vital importance. All of this conflicts, and I'm coming on to the law, with the constitutional law principle that the executive is subject to parliamentary scrutiny. And it's enough for our case to apply, as the Deputy President put to me on Tuesday, the Padfield principle that a minister can be shown to have acted unlawfully in the exercise of a discretionary power because of the effect of the decision. And my friend Mr. Fordham was absolutely right this morning to emphasise that my Lord the Deputy President's judgment in the Unison case is again based on impact. It's not based on there being any need for a malign motive. But I add, if necessary, and on my case it is not necessary, I would go further, if necessary, and invite the court to draw the inference that the length of the prorogation was motivated or at least strongly influenced by the Prime Minister's wish to prevent scrutiny by Parliament because he regarded Parliament as a threat to the successful implementation of his policies. There is no rational reason for a 5-week prorogation, giving the Prime Minister the broadest possible margin of discretion. And if that's right, the court is entitled to draw an inference that there was an improper reason. See Padfield. I remind the court that in opening I referred to 2 interviews given by the Prime Minister himself on the 30th of August. It was our trial bundles tabs 54 and 55. The court will recall it was a BBC interview and a Sky News interview. And in each of those, the Prime Minister himself stated that Parliament was a threat to the implementation of his policies. Neither of my friends, Lord Keane nor Sir James, addressed that evidence. The documents on which the government relies are of limited assistance to the court because there is no witness statement by or on behalf of the Prime Minister telling the court that they contain the only reasons for a 5-week prorogation. May I turn to the law? The argument advanced by both of my friends has 2 main limbs. First, they say the issues are not justiciable. And second, they dispute that there is any relevant principle of constitutional law. We respond that those 2 points go together. If, as we submit, there is a relevant principle of constitutional law, that is the supremacy of Parliament and the inferior status of the executive and its accountability, then it is a question of law for the court whether, in the light of that principle, this decision is outside the proper scope of the legal power to advise on prorogation. Sir James accepted, and properly so, in answer to my Lord Kerr, that it is for the court to decide the proper scope of a prerogative power. We submitted, and we maintain the submission, that parliamentary supremacy is a principle of our law. It is as fundamental as the rule of law and access to justice. It is not a mere convention. And it is not confined, as Sir James submitted, to an obligation on the executive and the courts to comply with enacted statutes. That is a consequence, an important consequence, of parliamentary sovereignty. But another feature of the legal principle of parliamentary sovereignty is that the executive is answerable to Parliament. And it therefore follows, we say, that the executive, the junior partner, cannot claim a legally unfettered power to close down the senior partner for as long as the executive likes, for whatever reason it likes, and however substantial the damage to the ability of Parliament to perform its scrutiny functions. Sir James then said that for the court to intervene would breach the principle of the separation of powers. Our answer is that the court is being asked to intervene in order to uphold the separation of powers. That is to ensure that the executive cannot, by its own acts, escape from scrutiny by Parliament. Sir James then says there are no judicially manageable standards. He points out correctly that any prorogation involves a limitation on parliamentary sovereignty. He asks how many days of prorogation is lawful? What reasons may justify prorogation? Our answer is that the court will, in this case, carry out precisely the function that it performs in other public law cases. It applies the relevant legal principle, here the supremacy of Parliament and the answerability of the executive, to the circumstances of the case. It looks at the length of the prorogation. It looks at the reasons given for the length of the prorogation. It looks at the adverse impact on parliamentary scrutiny. It looks at any inferences the court thinks it appropriate to draw as to whether at least part of the motive was to avoid parliamentary scrutiny. And having done all that, the court asks itself whether, in the light of all those circumstances, and applying, I accept, a generous margin of discretion in favour of the Prime Minister, whether his decision, his advice, is beyond the proper scope of his powers. This is standard business in judicial review in all other contexts. Was this decision reasonably necessary to further a legitimate objective, conferring a broad margin of discretion because of the context? And I say it is not, with great respect, it's not the function of the court to identify all the circumstances in which prorogation would be lawful. And the court does not need to supply a bright line standard, an algorithm, to answer all circumstances. A good example of that is the judgment of my Lord the Deputy President in the Unison case. The fees charged by the Lord Chancellor to those wishing to bring proceedings in the Employment Tribunal were unlawful, and they were unlawful because of the adverse impact on the constitutional principle of access to justice. And they were unlawful even though it would be lawful for the Lord Chancellor to charge some fees. And the court was not identifying, how could it, where the dividing line would fall. Sir James then referred to various acts of Parliament, including the recent Northern Ireland Act. And I say none of them assists in this exercise because none of them can be said to involve a parliamentary intention to remove the obligation on the executive only to exercise its powers in a manner lawful under the relevant principles of our constitutional law and our judicial review. Then finally, Sir James relied on the fact that the authorities have suggested that the power to dissolve Parliament is unreviewable, and the court has expressed interest in that matter. I respectfully agree with what the Lord Advocate and Lord Garnier submitted this morning. Dissolution of Parliament serves a vital constitutional function in ensuring democratic accountability of the members of the House of Commons. But I add a further factor. Prior to the abolition of this prerogative power in 2011, it was unreviewable because it was a personal prerogative of the Crown. See RFV Houston, Essays in Constitutional Law, its authorities, our authorities, the Miller authorities, Volume 5, Tab 81, and the relevant passage starts at page 75 and continues to address this question at pages 79 to 80. Now, my Lord Carnworth asked Sir James whether it was his submission that Her Majesty does enjoy a personal prerogative in relation to prorogation of Parliament. And Sir James was very clear in his answer. He said, "I am not making any such submission." And that answer, the court will recall, is consistent with what happened in this case. I showed the court in opening the radio interview with the President of the Council, Jacob Rees-Mogg.
I think he said, "I'm not making any positive submission to that effect." But
yes, I'm not making any such submission. It's no part of his case.
No, I
it's
think
no
that's
part of
what
his
I'm
case. And it's our argument is to the contrary. And I say it is entirely understandable why Sir James did not make a positive submission that Her Majesty does enjoy a personal prerogative in relation to prorogation. And the reason, I respectfully submit, is that given in argument by my Lord Sales. It would be profoundly unsatisfactory in a constitutional democracy governed by the rule of law if the court were to conclude that there does not need to be any legal controls on this power because any abuse can be addressed by Her Majesty. That would place Her Majesty in a quite impossible position. Remedy. The remedy we seek from the court is a declaration that the Prime Minister's advice to Her Majesty was unlawful. And we would respectfully ask the court, if it is in our favour, to make such a declaration as soon as possible, no doubt for reasons to follow. As soon as possible, because time is of the essence. We do not accept the argument, respectfully do not accept the argument advanced by my friend Lord Keane that Article 9 of the Bill of Rights immunises the order in council or any action that was taken in reliance upon it. And that is because the order in council was based, if our submissions are correct, on unlawful advice. The order in council is not a proceeding in Parliament. It precedes the proceedings in Parliament. And therefore, if necessary, we would argue that the court is able to give further relief. However, we would expect, in the light of a declaration, that the Prime Minister will ensure that Parliament resumes as soon as possible next week. And we consider that the appropriate way forward is for these matters, in the light of a declaration, to be addressed by the Prime Minister, by politicians, and by the parliamentary authorities. And we recognise that unless it is necessary to do so, this court will understandably be reluctant to grant further relief. The court understandably will be anxious not to take any steps that may be seen as trespassing on the exclusive right of the Houses of Parliament, quote, to determine the regularity of their own internal proceedings. I quote from Lord Simon in the Pickin case at page 799A. So
However, of course, Parliament needs to have, in your scenario, it needs to have the opportunity
it does.
to do that.
It does.
So it would need to meet as soon as possible in order to decide what it's going to do next.
Exactly so, my lady. And I emphasise, although we are seeking only a declaration, it's an important declaration, we would ask the court, if it's with us on the merits, to give an indication, if the court thinks it appropriate, an indication of what the court expects now to happen. That is, for Parliament urgently to meet so that Parliament can decide what happens next.
Can I ask,
yes,
does Parliament have power to determine that it had not been prorogued and then to save all the bills that were lost or seemed to be lost when the purported prorogation happens?
In my submission, Parliament would have power to do what it thinks appropriate in this most unusual situation, and were it to decide that by reason of the prorogation having been based on unlawful advice, if the court's with us, from the Prime Minister to Her Majesty, that it would then, in the view of Parliament, to be appropriate to treat the prorogation in parliamentary terms as null and void, then that decision could not be challenged in the court, because that decision would undoubtedly be a decision that was a decision concerning the regularity of their own internal proceedings. And I am submitting that the appropriate way forward in this unusual and difficult circumstance is to let Parliament sort out the problem. But it can only do so if, first, the court grants a declaration that the advice was unlawful, and if the court, with great respect, thinks it appropriate to do so, encourages the Prime Minister to ensure that Parliament meets as soon as possible next week. If unhappy...
Does the Prime Minister have to do anything to ensure that Parliament meets next week?
Well, it may be that the Speaker of the House of Commons and the Lord Speaker in the House of Lords, if this court were to declare speedily that the advice was unlawful and that this court is not going to give any further remedy because it expects that matters will be dealt with in Parliament, that the Lord Speaker and the Speaker of the House of Commons will take action to ensure that Parliament reopens as soon as possible next week. It's a matter for them. And then Parliament can debate, and Parliament will decide exactly how it wishes to proceed. And in my submission, that is the appropriate way forward. It's not for this court, I respectfully submit, to become involved in those matters unless it really has to, unless the matter needs to be looked at further.
Well, I quite understand that, but do I correctly understand your submission that if a declaration of unlawfulness in relation to the advice is given, it doesn't require any intervention by the Prime Minister? It's really a matter then for Parliament.
That would be my submission. It would be a matter for the Lord Speaker, the Speaker of the House of Commons, to decide how best now to proceed. They would know, in that contingency, they would know that this court, the Supreme Court, had ruled that the Prime Minister's advice, which led to the prorogation, was unlawful. They would know, if the court were prepared so to indicate, that the basis of that declaration was that the court took the view that the parliamentary scrutiny was required for legal reasons, and no doubt politicians and others would be asking the Speaker of the House of Commons and the Lord Speaker to reassemble Parliament so that Parliament can decide as soon as possible next week how they think, how Parliament thinks it best to proceed. This court would have done its job, and it would then be back to Parliament. All that could stand in the way of that would be if the Prime Minister, and I very much hope that this is unrealistic, that the Prime Minister hears of a declaration, hears of indications from the court, but says, well, I'm simply not going to take action. In those circumstances, we would submit that it would be open to the Speaker of each House to reassemble Parliament, if they so wished.
He doesn't have to take action on your submission.
In my submission, no.
I'm just wondering about the possibility that this might lead to a further constitutional clash. The implication of Lord Keane's submissions, as I understood them, was that even if this court were to declare that the advice was unlawful, Parliament would nevertheless stand prorogued, because the prorogation, he submits, is nonetheless effective. And following that logic, Parliament could not meet again unless, I suppose, a proclamation were to be made under the 1797 Act, which would have to be initiated by the Prime Minister.
My answer to that is if the court gave a declaration, and even if the court, as I'm suggesting, gave no further remedy, it would be implicit in that what followed from the advice was infected by the illegality, the unlawful nature of the advice. And if it were thought appropriate by the Lord Speaker and the Speaker of the House of Commons, notwithstanding the view of the Prime Minister, to reassemble, there could be no legal challenge to that. Parliament would be deciding how best to proceed. There could be no legal challenge to any decision that was made by Parliament itself as to what to do next. That's my submission.
I just wonder whether people don't need to have a clearer view, whatever the outcome of these proceedings are, where everyone is left. I mean, if we uphold your appeal, isn't it going to be very important, not least because of the time constraints which you've urged upon us, that it's very clear who is the person in law from whom further steps are required? Is it the Prime Minister, which it would be if Parliament is prorogued, as I understand it, or is it the Speakers, which it would be, as I understand it, if Parliament was not prorogued? Don't people need to know where they stand a little bit more clearly than you're indicating?
Our concern is that time is passing. And if this court is going to make a ruling on these questions, it will inevitably, we fear, take this court longer than if this court simply decides to declare illegality.
Just make an assumption that whatever this court thinks the answer in substance is to these proceedings, this court will produce that answer as soon as it humanly can. Make that assumption.
I'm very grateful. I've made my submissions. It's self-evidently a matter for the court how it thinks it best appropriate to proceed. My submission is governed not just by questions of time, it's also governed by the standard approach when we come to remedies, as my Lord better than most knows, that the court only does what it needs to do. And it doesn't do more than it needs to do. But I take your Lordship's point. It may be helpful, probably would be helpful, for the court to say as much as it can within as speedily as possible in relation to these matters. Clarity is very important, so everybody knows where they stand. I entirely take the point that my Lord is making.
If the advice was unlawful, has there nevertheless been a valid prorogation?
Yes.
Can we duck that?
I'm not suggesting that the court ducks it. I'm politely suggesting to the courts that it does as much as it can, as quickly as it can, if it's with us on the merits. And the danger, the concern, is that it takes the court a lot longer to resolve that question than simply to give a declaration and an indication. And time is passing. We have already lost, effectively, 2 weeks of the 5 weeks.
But your submission, Lord Pannick, surely has to be that if the advice is unlawful, then any action taken upon it cannot be valid.
It is my submission. It is my submission.
And although you're not asking us to go further, there is an order in the Scottish proceedings to the effect that the prorogation is of no effect.
I take
and we're being asked by Lord Keane to recall
That is also
that order.
That is true. But I'm anticipating, this may be impertinent, that the court is going to give an answer as soon as possible, as soon as humanly possible, to use the President's word, but it's going to give a reasoned decision at a later stage. I assume that the court is not going to produce it all in one go.
Make no assumptions
I make
whatsoever.
no assumptions. I make no assumptions. We are asking the court to do whatever it thinks is appropriate in these circumstances. I've made my submissions, but I take my Lord's Deputy President's point in relation to this, and I take the point made by Lord Sales and Lord Wilson.
I may have misunderstood you, but when you talk about a declaration of unlawfulness, does that extend only to the advice or also to the standing of the order in council?
Well, we have asked only for a declaration that the advice of the Prime Minister was unlawful.
Yes.
But, as is put to me, it is an inevitable consequence of a conclusion to that effect that the order in council was also unlawful, if I be right, that Article 9 can't protect it because it's not a proceeding in Parliament. That's how I put it.
Is it possible that there's a sort of two-stage solution? Because what you're suggesting is a course that might avoid another major constitutional question having to be resolved on this appeal. Yeah. Namely, is it the court which has jurisdiction to give relief, or is it Parliament's sole prerogative in relation to the conduct of its own proceedings? Is it a two-stage matter, possibly, that if the court were minded, and I'm certainly not giving any indication, to be in your favour, then it could defer that question to see what happened, or what?
Well, that's was what I was submitting to the court when I started this submission on remedy, that the appropriate way forward may be for the court to give a declaration, if it's in our favour on the merits, to give an indication of what it thinks now ought to happen over to Parliament, but if necessary, the court would have to inevitably have to deal with a further thorny constitutional question of whether further relief is appropriate. But that may be unnecessary. It may be that in the light of a declaration and an indication, this matter can be resolved in Parliament.
Well, I'm sure that Mr. O'Neill would say that he's asking us to uphold the interlocutor of the inner house.
Yes. Yes. Well, I'm reminded, I'm grateful by Mr. Fordham, that paragraph 17 of the note that the Prime Minister and the Advocate General for Scotland presented to the court this morning, paragraph 17, does say that the court may find it would be unlawful for Parliament to remain prorogued for any further period, and that advising the Sovereign to bring forward the meeting of Parliament pursuant to the Meeting of Parliament Act 1797 is the only option lawfully open to the Prime Minister. In that event, a declaration would be sufficient on the basis the Prime Minister would comply with the terms of a judgment having that effect. So, as I understand it, if the court were to indicate that that's the only option lawfully open to the Prime Minister, then the Meeting of Parliament Act provides the answer.
But then all the bills would have fallen.
That is, yes, subject to Parliament deciding that in these exceptional circumstances a different approach ought to be taken.
Well, we will have to decide what the answer is, and we will have to decide in one way or another what the consequences of that answer are.
Indeed so, my lady.
It's not... none of this is easy.
No, I don't suggest it is, and that may be why the suggestion of my lady, Lady Arden, which is what I was grappling towards when I was opening these submissions on remedy, may be the best way forward. One takes it in stages. But that's a matter, of course, entirely for the court.
So you'd be asking effectively for a limited declaration, meantime, with leave to apply?
Yes, with leave to apply, and if the court thought it appropriate, an indication of what the court hopes and expects will happen next. And if it doesn't happen, then the court will need to grapple with the question of whether to grant further relief, which we hope will not be necessary. Those are the submissions on behalf of Mrs. Miller, unless I can seek to assist the court further.
No. Thank you.